International law jurisdiction over cybercrimes. The rapid evolution of cyberspace in the 21st century has fundamentally reshaped global interactions, presenting unprecedented challenges to traditional international legal principles, particularly those governing jurisdiction over criminal acts. Cyberspace is characterized by its borderless nature and dynamic spatio-temporal dimension, allowing it to operate outside the confines of conventional territorial jurisdiction, which historically regulated criminal and civil laws in international disputes. Cybercrime, defined broadly to include offenses against and by means of computer, data, and systems, is a global phenomenon where effective prosecution is often hampered by conflicts of territoriality and jurisdiction. The crucial difficulty lies in establishing how instruments of international law can effectively regulate this complex domain while respecting fundamental principles such as sovereignty and human rights. International law traditionally recognizes 6 generally accepted principles of jurisdiction: subjective territoriality, objective territoriality, nationality, protective principle, passive nationality, and universality. Territoriality is historically the preferred basis for jurisdiction. Subjective territoriality applies if an activity takes place within the territory of a nation-state. Objective territoriality is invoked when an activity occurs outside the state's territory, but its primary effect is felt within that state. However, the intangible nature of cyberspace makes applying these principles challenging. For instance, determining whether an offense in cyberspace was committed within a specific state's territory is not a simple task, often leading to the rejection of the territoriality principle in this domain. The complexity is exacerbated by technological realities, such as cloud computing, which results in a loss of location problem, making it difficult to determine where data is stored and which legal regime applies. Data processing can be fragmented across servers in different countries, creating a technological black box for regulators. Despite these difficulties, states assert jurisdiction using modified applications of the traditional principles. Objective territoriality, often conflated with the effects principle, allows a state to claim jurisdiction if the results or effects of the cyber activity are produced on its territory, such as interference with computer data or injury to persons. This principle is particularly emphasized when subjective territoriality fails to pinpoint the conductor's location. Similarly, the protective principle allows states to assert jurisdiction over acts significantly impacting their national security, regardless of the crime's origin, directly addressing the need for security in the cyber realm. The nationality principle, active personality, asserts jurisdiction based on the offender's nationality, regardless of where the act occurred, and remains widely recognized as a major basis for establishing jurisdiction after territoriality. Passive nationality asserts jurisdiction based on the victim's nationality. Finally, the universality principle permits jurisdiction over certain crimes of universal concern, such as genocide or war crimes. While cybercrimes like child pornography have sometimes been subject to universal jurisdiction claims in some states, such universal claims regarding cybercrime remain controversial due to the lack of consensus on specific definitions of these offenses globally. The application of these expansive principles, coupled with the borderless nature of cyber activity, often leads to situations of overlapping jurisdiction, where multiple states can legitimately claim jurisdiction over the same conduct. This necessitates mechanisms to prioritize claims, although no customary rule exists to regulate this prioritization. Factors considered in resolving these conflicts include the degree of harm caused, the nationality of the offender and victims, and the availability of evidence. Beyond the prescriptive jurisdiction, the capacity for enforcement jurisdiction presents the most significant limitation on criminal justice in cyberspace. Enforcement jurisdiction, typically restricted to a state's own territory, is challenged by the need for cross-border collection of electronic evidence. Investigations require various data types, subscriber information, traffic data, and content data, which are frequently stored on servers in multiple or unknown foreign jurisdictions. The traditional tool for obtaining evidence abroad, mutual legal assistance, is largely deemed inadequate for the rapid demands of cybercrime investigations. Assessments of the mutual legal assistance provisions of the Budapest Convention concluded that the procedures are too complex, lengthy, inefficient, and resource-intensive to cope with the volatile nature of electronic evidence. Evidence in the digital realm is fragile, easily altered or destroyed, and timely access is critical before private sector data retention periods expire. In the absence of efficient international cooperation mechanisms, governments sometimes resort to unilateral solutions, such as compelling a service provider within their territory to produce data stored in another jurisdiction, raising risks for interstate relations and individual rights. The global community has pursued various avenues to establish a coherent legal framework. The Budapest Convention, 2001, the Council of Europe's Convention on Cybercrime, is the only legally binding international multilateral convention focused on the digital domain. It aims to harmonize national legislation, enhance investigative tools, and strengthen international collaboration, serving as a benchmark for international standards. It sets common minimum standards for relevant offenses and lays down procedural laws for the collection of electronic evidence and mutual legal assistance. The convention requires parties to establish jurisdiction based on the territoriality principle, flag principle, and active nationality. However, its regional origins and failure to achieve universal acceptance limit its efficacy as a global standard, and it lacks clear criteria for resolving positive jurisdictional conflicts. The UN Cybercrime Treaty, Draft. Recognizing the limitations of regional instruments, the UN General Assembly established an open-ended ad hoc committee in 2019 to elaborate a comprehensive international convention on countering cybercrime, aiming for the first globally binding treaty in this field. The final draft text, adopted in August 2024, seeks to strengthen international cooperation for combating crimes committed by means of ICT systems and for sharing electronic evidence. It criminalizes core offenses such as illegal access, illegal interception, and data interference, while explicitly affirming that obligations must be carried out consistently with principles of sovereign equality, territorial integrity, and international human rights law. International Criminal Court, ICC. The ICC, with jurisdiction over genocide, crimes against humanity, war crimes, and aggression, does not prosecute ordinary cybercrimes punishable under domestic law. However, the Office of the Prosecutor recognizes that the provisions of the Rome Statute are technology neutral and can apply to crimes committed or facilitated by cyber means. The ICC's jurisdictional framework, temporal, territorial, and personal jurisdiction, applies to cyber-enabled crimes. For territorial jurisdiction, the Office of the Prosecutor views it covering both subjective and objective territoriality, extending to the state where the criminal conduct began and where it was completed. The ICC emphasizes that cyber conduct, while rarely the crime in isolation, may often facilitate kinetic crimes, physical crimes, or provide contextual evidence necessary for proving international crimes. The regulation of cyberspace through international law remains both a necessity and a deep challenge. The fundamental conflict persists between the state's sovereign right to control its territory and the imperative for transnational cooperation demanded by the interconnectedness of the digital domain. The borderless nature of cybercrime continues to defy traditional principles like territoriality, making expansive and sometimes conflicting jurisdictional claims inevitable. While existing mechanisms like the Budapest Convention and the ICC's application of the Rome Statute offer foundational responses, a standardized, adaptable, and universally binding approach is crucial to effectively combat digital threats and curb cybercrime safe havens. The ongoing negotiation of the UN Cybercrime Convention represents the strongest attempt yet to codify universal legal frameworks, focusing on balancing sovereignty and security with human rights protection. Ultimately, future legal frameworks must not only enhance transnational cooperation and capacity building, but also ensure that the exercise of jurisdiction is consistently justified and reasonable to maintain international comity and uphold the rule of law in the digital age.